Good day to you, Dr. Vijaya. My name is Queenie Tang, student ID 036627. Constructive trusts are imposed by operation of law, regardless of the party's intentions. As Miller LJ explained, a constructive trust arises whenever equity considers it unconscionable for the legal owner of property to deny another person's beneficial interest. Critics argue that constructive trust grants judges excessively broad discretion and create uncertainty in property law. Conversely, supporters contend that constructive trusts perform an essential equitable function by preventing fraud, unjust enrichment, breaches of fiduciary duty, and other forms of unconscionable conduct. One of the strongest justifications for constructive trust is that they prevent parties from relying on legal ownership to perpetrate fraud or unconscionable conduct. In this regard, constructive trusts enable the courts to prioritize equity over strict legal formalities. This principle was highlighted in Hussey against Palmer, where Lord Dennis stated that a constructive trust arises whenever justice and good conscience require equitable intervention. The principle is clearly illustrated by Bannister against Bannister. The court imposed a constructive trust holding that it would be fraudulent and unconscionable for Mr. Bannister to deny Miss Bannister's beneficial interest after inducing the transfer through his promise. The decision demonstrates why courts have been fair in imposing constructive trust. Had the court refused to intervene merely because no trust was intended, the defendant would have been allowed to rely on strict legal title to benefit from his own unconscionable conduct by unjustly retaining property. In Pennant against Morgan, although no trust relationship was intended, the court imposed a constructive trust because permitting the defendant to retain the land solely for himself would effectively sanction a fraud. The case demonstrates that constructive trusts are often necessary to prevent legal ownership from being used as an instrument of injustice. In Paragon Finance PLC, Millard LJ explained that constructive trusts arise in these two situations. This shows that constructive trusts are imposed not primarily because the parties intended to create a trust, but because equity considers it unconscionable for a party to retain the beneficial interest in the property. This rationale is consistent with the views of Professors Hayton and Marshall, who explained that constructive trusts may operate against the current wishes of the legal owner, where it would be unconscionable for that person to deny another's beneficial interest. In this sense, constructive trusts are imposed not to enforce intention, but to respond to wrongdoing and prevent unjust enrichment. A similar approach was adopted in Malaysia, where the court in Foreign Malaysia Berhad recognized that constructive trusts may arise from wrongful conduct renders it inequitable for a party to retain property obtained at another's expense. This principle was further reinforced in West Deutsch, where Lord Brown Wilkinson stated that constructive trusts arise where the defendant possesses knowledge of circumstances affecting his conscience, making it inequitable for him to retain the property. Courts have also been fair in imposing constructive trusts where property is acquired through wrongdoing. The doctrine ensures that individuals do not profit from their own misconduct, even where no trust relationship was intended. This rationale is evident in FHR European Ventures LLP. The court held that the bribe was held on constructive trust for the principle. The imposition of a constructive trust was fair because fiduciaries should not profit from breaches of duty committed at the expense of those whom they represent. In the estate of Crickburn, the court treated the husband as holding the property on constructive trust for the rightful beneficiaries. Although no trust was intended, the imposition of a constructive trust was justified because equity does not permit a wrongdoer to profit from his own wrongdoing. These authorities strongly support the view that courts have been fair in imposing constructive trusts because the doctrines serves as an essential equitable function in preventing individuals from profiting through fraud, breaches of fiduciary duty, criminal wrongdoing, and other forms of unconscionable conduct. Despite these justifications, constructive trusts have been criticized as potentially unfair because they create uncertainty and confer excessively broad judicial discretion while imposing proprietary rights. This concern is illustrated by Eves against Eves, where Lord Denny imposed what has been described as a constructive trust of a new model based largely upon considerations of fairness and inequity. This unrestrained unconscionability approach was criticized by Dean J., who cautioned that constructive trust cannot be used as a medium for the indulgence of idiosyncratic notions of fairness and justice. Malaysian jurisprudence on constructive trust have has also been criticized for relying too heavily on vague notions of unconscionability and invoking remedial constructive trust without imposing sufficiently clear doctrinal limits, as evidenced in RHB Bank Berhad case. Critics further contend that expressions such as unconscionable conduct, demands of justice, and good conscience often provides confusion rather than guidance due to the innate ambiguity of such language. Consequently, the imposition of remedial constructive trust risks becoming dependent upon individual judicial perceptions of fairness rather than clearly established legal principles, and similarly situated parties may be treated differently, thereby undermining equality before the law and fairness. Besides, the Malaysian Federal Court has shown a progressive willingness to recognize remedial constructive trust when necessary to rectify injustice. In Techu 4, the court affirmed that a remedial constructive trust may operate as a judicial remedy where circumstances warrant equitable intervention. As noted by In Kai Liu, claimants under a remedial constructive trust possess no rights born of any facts which have happened outside the court. Unlike institutional constructive trusts, which arise automatically from established facts, remedial constructive trusts depend upon a subsequent judicial decision. Since courts may impose such trust without having to satisfy any established or elucidated rules and requirements, critics argue that the doctrine risks lacking a principled rationale for the availability of proprietary remedies. For this reason, In Kai Liu and Han Wu Dan 2025 argue that courts should not determine cases merely through direct and uncritical appeal to good conscience. Instead, judges should first carefully consider whether the facts fall within recognized categories of constructive trust before deciding whether equitable intervention is justified. The need for doctrinal clarity becomes even more apparent when the imposition of a remedial constructive trust in this fashion may result in being a proprietary claim which has the following consequences, such as giving the claimant priority over other creditors in the event of bankruptcy and so on. These consequences may substantially affect third parties and creditors who were not involved in the original dispute, other than the parties in dispute. Accordingly, clarity of the parameters of the element laid down in which constructive trust arise is essential. Courts should adopt a structural approach grounded in restitutionary principles to avoid creating proprietary rights that unjustly enrich claimants at the expense of others. Lord Brown Wilkinson suggested Obiter that remedial constructive trust could be tailored to the circumstances of the particular case to avoid prejudice to innocent third parties and paltry justice. Nevertheless, English courts have generally remained cautious regarding remedial constructive trust. In Rare Polypack, the court expressed concern that judicial discretion to create proprietary rights retrospectively could undermine statutory insolvency schemes enacted by Parliament. In this regard, in Bailey case, the court highlighted that the mere prospect of a total failure of consideration does not grant a proprietary restitutionary claim. This demonstrates that English law maintains clear boundaries around when proprietary remedies through constructive trust will be available to preserve consistency and predictability in proprietary disputes. If constructive trusts are imposed solely on subjective notions of fairness and without recourse to further rationalization, they may ultimately undermine legal certainty and produce unfairness to third parties. These concerns became more apparent following the Api case. Also, the federal court recognized constructive trust as a remedial mechanism grounded in unjust enrichment and equitable intervention. The court did not clearly identify unjust enrichment as a necessary basis for restitutionary relief, thereby creating uncertainty as to when constructive trust should properly arise. Therefore, the mere fact that courts impose constructive trust without the party's intention to create a trust is not inherently unfair. The real question is whether judicial discretion is exercised within recognized legal constraints. As scholars have observed, the imposition of transformative constructive trust is far more contentious than reflective constructive trust because the former carry a greater risk of unbridled judicial discretion. This is not an issue in relation to reflective constructive trust because the exercise of discretion is constrained in terms of the goal of the remedy. For example, the exercise of remedial discretion is constrained by the remedial goal of compensating A for harm suffered through the unreliability of B's induced assumptions. This is why the exercise of discretion and the retrospective effect of a constructive trust award do not automatically cause any uncertainty and unfairness in this doctrine. Moreover, complete rigidity would undermine the very purpose of equity. Equity developed precisely because strict legal rules were sometimes incapable of producing fair outcomes. As Tay 2011 observes, judicial pronouncements have deliberately left the boundaries of constructive trust somewhat vague so that courts are not restricted by technicalities in achieving justice in particular cases. A wholly rigid system might promote certainty, but it would also risk allowing fraud, unjust enrichment, and other forms of unconscionable conduct to go unchecked merely because the facts do not fit neatly within established categories. Such an outcome would itself be unfair. Professor Peter Burks emphasized that flexibility and sensitivity are properties of the whole law, but such development must occur only on the margins of a stable system, the stability of which depends on careful analytical method within a sound taxonomy. The objective is therefore not to eliminate judicial discretion altogether, but to ensure that discretion is exercised according to principal legal standards. Importantly, Malaysian courts have generally exercised restraint rather than imposing constructive trust arbitrarily. Even in the Api case, the federal court laid down a three-pronged test governing the imposition of constructive trust. Guidance on unjust enrichment was articulated more clearly in Dream Property Sdn Bhd 2015, where the federal court identified 4 elements that must be established. Although some inconsistency remains because later authorities such as the Api case did not expressly emphasize restitution-based unjust enrichment, despite earlier cases such as Seri Perak Sdn Bhd 1999 and Air Express International AIM Sdn Bhd 2012, the courts have nevertheless attempted to apply constructive trust within identifiable equitable principles in order to balance fairness and certainty. In English law, Stack against Dowden recognized that various factors beyond financial contributions may be relevant in determining the party's true intention. However, Malaysian courts have consciously declined to extend the doctrine of CICT to unmarried couples in the absence of financial contributions. This is reflected in Shirley Catherine Yap, where it was held that financial contribution is the only factor upon which common intention may be inferred. Although restrictive, this approach demonstrates judicial reluctance to expand constructive trust beyond established limits and reflects an effort to preserve certainty in proprietary disputes. Nevertheless, this restrictive approach is not free from criticism, as it may be argued that this approach will create an unfair outcome where vulnerable non-marital partners are left without any proprietary remedy despite having made significant sacrifices if there is no financial contribution, compared to married couples who receive more protection under Section 76 of the LRA 1976. For married couples, the court will consider both direct and indirect contributions when dividing matrimonial assets. Accordingly, although the law remains imperfectly fair, Malaysian courts have generally exercised constructive trust jurisdiction with restraint and principled reasoning. The greatest challenge is ensuring that constructive trust remains sufficiently flexible to prevent injustice while remaining sufficiently structured to preserve predictability, consistency, and fairness. In conclusion, the strongest criticism is therefore not that constructive trust should never be imposed without intention, or such imposition would automatically cause unfairness, but that courts must clearly identify the legal basis upon which such intervention is justified. As suggested by In Kai Liu and Han Wu Tang 2025, Malaysian courts should reappraise their methodology and also pay closer attention to pre-existing categories and identifiable equitable principles when determining whether a constructive trust should arise. On balance, the courts have been fair in imposing constructive trust even when no trust was intended by the parties, because based on the authorities, they have generally imposed constructive trust only where equity recognizes compelling reasons for intervention, such as fraud, unjust enrichment, abuse of fiduciary obligations, or the retention of benefits derived from wrongdoing. The Malaysian authorities further demonstrate that courts have attempted to balance flexibility with restraint rather than exercising unfettered discretion. Accordingly, constructive trust remain a justified and necessary equitable remedy, provided that courts continue to apply them cautiously, consistently, and within established doctrinal limits. Here is the reference list. That is all from me. Thank you for listening. Bye.